About the Payment of Wages Act 1936. The object of the act was to eliminate the malpractices in making payment to the employees. It fixes the period, who has to pay, when has to the wages have to be paid, that all things are given. The Act section 3 is for definitions. It defines who is an employer, which is a factory, who is an employee. One important thing we have to see is regarding wages. Section 2 subsection 6 says it means all remuneration whether by way of salary, allowances or otherwise. Expressed in terms of money or capable of being so expressed. That is, whether it is salary or allowances, it is included in the wages. It should be capable of being expressed in money or or capable of being expressed in money. That is, if something is paid in kind, that doesn't come under this category wages. This may be according to the agreement between the person, appointment order, all these things, or settlement or award. This includes the overtime wages, holiday wages, and this does not include the bonus. This does not include any amenities, facilities given like house accommodation given, not included in wages. This does not include the amount contributed towards a pension or provident fund, or travelling allowances, or anything paid for gratuity. These are things not included. This is according to section 2 subsection 6. Section 3 deals with the person who has to make a payment. That is the responsible person. The manager is employer is a responsible person. However, in the case of factory, if there is a manager, he will be responsible. In the case of railways and industrial establishments, the supervisor who is taking care of the management will be responsible. Same is the case with the contractors. The person responsible for that. Now, section 4, fixation of wage period. You can fix your own wage period, but the maximum wage period is, the length should not exceed more than 1 month. We see that in case of concession companies, it is 1 week. Every Saturday they get their wages. But the factory people, they get only once in a month. Now, time of payment of wages, section 5. The section 5 says, if the number of employees in a factory or an industrial establishment is less than 1,000, salary should be paid before the expiry of the 7th day from the closure of the wage period. If it is March 1st to March 31st, within 7 days, that is before 7th of April, wages should have been paid. If the employees in the unit, that is in the factory or industrial establishment, is more than 1,000, the wages should be paid before the expiry of the 10th day. If the wage period is March 1 to 31st, wages should be paid before 10th of April. Another case, if it is based on the task, completion of the task, like loading, unloading, based wages paid on tonnage of work completed, in such a case, it should be paid before the expiry of 7th day from the completion of the task, like unloading from the ship. In such a case, after the completion of the job, 7 days. Before the expiry of the 7th day, they should pay it. In the case of a person is terminated from employment, within 2 days should be paid. Now section 6. Section 6 says how to pay. It says it should be paid by current coin and currency. That is, only by cash you can pay. You cannot pay by check or credit to account. If it is there, you have to get a concurrence or authorization from the employees. Next, section 7 says you make the full payment to the person. You cannot deduct it, but there are some authorizations to deduct. Some authorized things. That is like fines, number 1. Number 2, absence from duty. Number 3, damages or losses. Recovery towards damages and losses. Fourth, recovery towards the housing accommodation given to the employees. Recovery of advances and adjustments of overpayments of wages. Recovery towards loan. Then recovery towards the subscription or to the provident fund or advance recovery from the provident fund. Income tax recovery. Deduction towards income tax, payment of cooperative societies or insurance. Next is, if at all that the employee wants something to be deducted from him and to be paid by authorization, he can permit the employer to do that. This is section 7. The subsequent sections give further details. Section for the first was the fine. Section 8 deals with the fine. If anything to be recovered as a fine, there must be a previous approval from the state government or from the prescribed authority. For any act or omission, if the employer wants to recover fine, impose fine on the employee, there must be a scheme. This should be approved by the state government or the employee or the prescribed authority. Number 1. Number 2, it should be notified in the notice board or somewhere. All the employees should know that. And if the person has committed an act which attracts fine, then the person should be given an opportunity to explain his stand. Show cause notice should be given to him. After hearing him, fine can be imposed. For example, a factory may have a scheme that loss of identity card. If identity card is lost, 100 rupees fine. This should be a scheme approved by the state government or the officer concerned. It should be placed on the notice board. The person should know. If a person has lost it, then a notice to him, show cause notice. Why 100 rupees cannot be recovered from you? Because you have lost your ID card. Then he will say, sir, I was going by bus. The bus met with an accident. I lost all my belongings. This ID card also lost along with that. In such a case, the employer may waive that fine. The conditions for recovery of fine is, it should not exceed 3% of the wages. For example, if that person wage is 1,000, you can recover the maximum 30, not 100 as per the scheme. Fine cannot be recovered in installments, and the fine should not exceed 3% of the salary. Next, absence from duty. Absence from duty. The employer can recover wages for any absence from duty. 1. Next, the condition is you cannot take anything over and above the absence from duty. For example, 1 day absence, you cannot recover 3 days salary. Pro rata only. A person has absented from duty for 3 days, where the total number of days was 30. So, 3 days for 10% of the salary you can recover. Number 1. If a person has come, he was staying in the factory or in the unit, was not doing any work, then treat it as an absence from duty and recover wages. Third, there may be instances more than 10 persons may be absenting from duty. In such a cases, 8 days salary can be taken. That is, in normal cases like strike or any other industrial things, they should give a notice, trade union activities. And this person is going suddenly without any notice. For that, the Act permits to recover 8 days wages from the person absent from duty, where the absentees was more than 10. This is absence from duty. Next, deduction for damages or loss. If there is any deduction or damages or loss, he can recover the cost, nothing more than that. For example, a server in the tea shop, 10 glasses broken in a month, he can recover only the cost of the 10 glasses, nothing more than that. There also, employee should be given a show cause notice. Why we should not recover glasses, cost of 10 glasses? The person will come and say, no, it is not 10, I have broken only 9, you recover only 9 glasses. Show cause notice should be given, his view should be taken, then only you can recover the losses or damages. Number 11. Deductions for services rendered. In the case of providing quarters by the factory, they can recover rent or electricity given or water charges, everything. For the amenities, you can recover it. Next, deduction towards recovery of advances. If any advance is given to the party, they can recover it. For example, there may be a festival advance. Every Diwali they may give a festival advance to be recovered in the next 10 months, can be recovered. If a person is given advance even before employment, it can be taken from the first month itself. For example, a person may be a skilled worker working with another factory. What this employer will do, he will give you some advance and get him in his factory. In such a case, from the first month itself it can be recovered. Next, deduction towards the recovery of loans. If any loans are given, it should be approved as per the government rules. Recovery can be made towards the loan accounts. Next, deduction for cooperative societies and insurance schemes. For insurance schemes, recovery can be made. There may be a cooperative societies, there also insurance can be made. A recovery can be made towards the cooperative society. Section 13A says for all such things, the employer should maintain a register. Register of wages paid, register of recoveries made, register of fine collected, register of recoveries towards the damages, all such things should be there. Section 14, inspectors. These are the provisions of the Act. There must be somebody to see that everything is going as per the Act, provisions of the Act. For that, in the case of factory, the factory inspector under the Factories Act will be the person. In all other cases, the state government has to nominate a person as a inspector for the factories. They should be allowed to visit the factory or the industrial establishment, verify the books. They have the power to seize the books. They have the power to copy the records. They have the power to interact with the employees and to ensure that wages are paid in time. This is section 13 and 13A. Section 15 next. When there is a unauthorized deduction, when there is a delayed payment, the employee has to go to somewhere and say that this had happened. Government officials should enforce that these wages are paid in time, to see that wages are in paid. For that, the government should designate somebody for this purpose. For example, any commissioner of Workmen's Compensation Act or any regional labor commissioner, somebody will be designated. He has to see that these are any complaints are there, then the employee has to approach this person designated for this purpose under section 15 with a complaint that my salary is delayed or unauthorized recoveries have been made in my account. This should be done within 12 months. Within 12 months. The employee can do, or any other authorized person on his behalf can also submit an application, claim that this has been done, and this designated officer will send a letter to the employer to ascertain his views. After that, he will decide whether there is an unauthorized deduction or not, whether there is a delayed wage payment or not. Then only he will taken action. If the delay or unauthorized deduction is due to bona fide error or bona fide dispute. For example, bona fide error means a person might have taken loan. Due to monthly recovery, that loan account might have been closed, but without knowing that, these people might have continued to recover. In such a case, it is a unauthorized deduction. But no malified intention, it is by mistake they have done it. In that case, no action will be taken. Or bona fide dispute, this person may be claiming something, the employer may be saying that you are not eligible for that bona fide dispute. No action will be taken. Next is some emergency. The employer on the day of salary might have gone to his native place since his father was so sick. He could not draw money. After 2 days he came and paid his wages. Or there was a death in his close relative's house. He had to go. He could not go to the bank. In such a cases, some emergency, occurrence of emergency, he will be excused from delayed payment. Next is failure to apply or accept the payment. If the employee has not accepted it, the employee has not applied for it, then also no action will be taken. For example, in a factory, it is a practice to take the wages by standing in a queue. Everybody was standing, but this was not there. He was not standing there. After 3 days, he is telling my wages have not been given. No, he has not claimed it. He has not accepted it. In such a cases, no action will be taken. In all other cases, if we find out that there was an unauthorized deduction, he will impose penalty on that as per the prescribed amount that will be done. Next is when there are so many applications. For example, what I told that by mistake a person account was closed and by mistake recoveries were made for 10 or 15 persons. Then 10 or 15 persons will be submitting application to the person for unauthorized deduction. In such a cases, he can club together everything and then proceed for that. Section 17 deals with the appeal. If the persons are not satisfied with the decision of this government official, they can go to the next appeal by court. In the presidency towns to the small causes court. In the other places to the district court. They will decide whether there was a delay or whether there is unauthorized deduction. If there is any question of law, they will refer to the High Court and then decide the case. Before going to the appeal, the person has to pay the amount already. If there is a penalty, he has to pay the amount, get a certificate, then only he can go to the appeal. If the courts require that the person may not pay the amount, they can go for even for attachment of property. But before attachment of property, they have to ask the other person, that is employer's view also, then only they can go for attachment of property. Next we will see the bar on suits. No court can entertain a suit if the applications are pending before the government official as per section 50. They can take it only after the decision by way of appeal only. Next, 22A, protection of action taken in good faith. If any officer has taken any action in good faith, he cannot be proceeded against that. Only if he has acted in good faith, no action can be initiated against him. Section 23 is contracting out. That is almost all labor law acts will have this. That is at the time of employment itself, the employer will get a letter from the employee, for me this act will not apply. So that is not permitted. Nobody can take the rights given to the employee. That is not valid. Any letter is given, that is null and void. Nobody can take the right from that person. Section 25 says, display of by notice and abstract of the act. This act should be displayed in the factory or any industrial establishment, so that the employee should know that there is an act like this. These are our rights. For that, this section 25 says it should be placed in the notice board or some places so that the employee should know. Section 25 regarding payment of undisposed wages in the case of death and employed person. Death of employed person. If there is a death of employed person, the legal the amount should be paid. In case they are not able to pay it, it should be deposited with the government. There will be a prescribed procedure for that. The government will be making rules under this act. According to that, the amount should be paid to the government. Section 26 says the state government has the right to make the rules under the act. This is Payment of Wages Act. In the next session, we will see some more topic.